Hello, my fellow Alaskans. How are you all doing out there today? It is great to see you. It is Thursday. The week is almost over with, and I am sitting here with David Haeg, and he is going and is doing investigation on our Alaska grand jury and trying to solve the issue that they have themselves created, taking away our rights for the accountability of what is going on within our judicial branch here in Alaska. David Haeg, it is great to see you. It was very nice to meet you. Tell us who you are, why you're here, and what got this all started.
Okay, well, my name is David Haeg, and I live out here on Browns Lake, outside of Soldotna, Alaska. Have a wife and 2 daughters. About 18 years ago, I got involved with the court system. State of Alaska asked me to help them conduct the wolf control program. One thing led to another, and we ended up in a big tiff with the state of Alaska. Things didn't add up over time, and so we went to our business attorney and other attorneys, and they encouraged us to go to the FBI with what had happened. We did. The FBI confirmed that this has been going on for quite a few years and is getting worse. But one of the things that cropped up early on is evidence that Alaska's only judge investigator has been falsifying investigations to keep corrupt judges on the bench and, as I say, ruling over we the people. That evidence cropped up in, I think, about 2010. I and some other folks started filing complaints against her. And the Bar Association didn't do anything, nothing really happened. And eventually we figured out that, or people told us that grand juries in Alaska have this power to investigate and indict and write recommendations on things of concern to the public welfare and safety. And so I think it's about 5 or 6 years ago, we started approaching grand juries and asking them to investigate this judge investigator. And just so that people know, she gets about 20 complaints a month. She's been the only investigator since 1989, 33 years. And so she's the only one that has done approximately 8,000 judge investigations in this state. No other person has done any. And so once we started asking grand juries to investigate, they tried to do so. The evidence that we gave them, they wanted to investigate, but in every instance, the judges and usually the Deputy Attorney General, and most of the time it was the same guy, name's John Skidmore. He wasn't the Deputy Attorney General for the whole time, but he is now. They would come into the grand jury and flat order them to stop investigating. And this was of big concern because our Constitution says, quote, the power of grand juries to investigate and make recommendations concerning the public welfare or safety shall never be suspended. There's another thing that the delegates to our Constitution spoke that was going to go into the Constitution also, and that is, or that what they said that the wording that's in the Constitution, it also covers this, and this is from the delegates themselves. The power of grand juries to inquire into the willful misconduct in office of public officers and to find indictments in connection therewith shall never be suspended. And so grand jury after grand jury that wanted to look into this evidence was stopped. And obviously it violates the Constitution to stop the grand juries. And there's also some statutes that say I think it's, let me just try to remember, 12.40.040 and 12.40.050, and it may be 020. The legislature said if an individual grand juror knows or has reason to believe a crime has been committed, he shall inform the other grand jurors who shall investigate. It doesn't say should or may. It says that they shall. There's another statute that says tampering with a juror is a Class C felony, I believe. And so after about 5 grand juries were stopped, a bunch of us got together and said, this is a felony for these folks. The judges, one of the judges was Judge Jennifer Wells in Kenai, and then again, like I said, Deputy Attorney General John Skidmore. We said, we want these folks prosecuted or at least investigated by a grand jury, or we're going to conduct a citizen's arrest. And we went to the governor with that, and lo and behold, a grand jury was formed specifically to investigate this, and it was through the help of some legislators, my senator, and especially my representative.
Do you have, can you name who those were? Help highlight,
yeah.
Maybe we might have some heroes actually in Juneau this year?
Our senator that started the ball rolling early on was Senator Peter Machicki. He introduced Senate Bill 15, and this was several years ago. That bill kind of got hijacked and would have actually made things worse. And so it ended up not going anywhere, but then Representative Ben Carpenter helped get the ball rolling also. But kind of where it really got going is once we realized there was real teeth to what we were doing, a bunch of us started protesting at the Kenai courthouse on the day we knew the grand juries were meeting and waving signs, let the grand jury investigate, grand juries have the power, et cetera, et cetera. And then I think it was like a 6th grand jury, the majority of them voted to investigate, and Judge Wells stopped that, and I think John Skidmore. And that was the impetus to, in essence, force the government to let a grand jury start. Sorry, I'm coughing here. But anyway, to kind of get people up to speed, is that this grand jury, we gave them the evidence of this judge investigator, Marla Greenstein, and they started investigating. Shortly after that, the Alaska Supreme Court started rewriting Criminal Rule 6, which is the rules that govern grand juries, and they did it to eliminate the grand jury's power to indict, to investigate unless the government officials agreed, and also before the grand jury could issue a report and notify we the public of what they found, judges had the ability to go in and rewrite and edit what the grand jury had found. And again, all of this is in total opposition to what the people who wrote Alaska's Constitution said. And all of that is found on the Alaska Legislature's website. You go in and you can just Google Alaska Constitutional Convention. It comes up with, there's a transcription of the days of where they're talking. And then there's files that have the writings and what they were putting into the Constitution. And then it has, the Constitution itself has the actual words. But the words are very broad, and the delegates said that they wanted them broad so that the grand jury could an actual quote from the grand jury is, the grand jury can investigate anything. Another quote from them is, the grand jury in its investigative power, as well as the fact that it is sitting there as a panel, sometimes is the only recourse for a citizen to get justice, to get redress from abuse in lower courts. It is the only safeguard a citizen occasionally has when, for any reason, and very often for political reasons, a case is not dealt with properly. And what the Supreme Court did as soon as this grand jury started investigating is they went in and rewrote the rules, Criminal Rule 6, to eliminate all of these rights that the delegates specifically said a grand jury has. And so what the Alaska Supreme Court did is blatantly unconstitutional. I'll give you...
Give us a time frame here, because I know that on my end, I'm well versed on what you're talking about here, but those that are watching, are we talking...
Immediately after a grand jury started investigating judicial corruption, immediately after they subpoenaed the judge investigator in Alaska for 33 years, 8,000 investigations, that immediately after that, they came in and rewrote the rules. And I'm going to just quote one of the rule changes that they did to Rule 6.1.
So what is the normal procedure then when you're going to change the rules? It sounds like the Supreme Court judge there is virtually just any accountability, anybody that would be oversight to them has been ignored. Do they just not exist, or what happened? Where's the breakdown here?
Well, that is funny you asked that, because they did. They ignored all the oversight. For changing the rules, there is a criminal rules committee made up of 13 members. A number of them are judges, a number of them, I believe, are public persons, a number of them are attorneys. In this case, the committee that should have been involved in the rule change are Judge Patrick Hanley, Judge William Carey, Samantha Cherut, I don't know who she is, Judge Jason Geist, Judge Bethany Harbison, Robert Hers, Douglas Moody, John Murtaugh, Gustav Olson, Trina Sears, Sarah Stanley, Judge Thomas Temple, and Taylor Winston. And then there's a rules attorney, Stacy Steinberg. We obtained a memorandum from court rules attorney Stacy Steinberg to the Chief Justice, Justice Masson, Justice Carney, Justice Borgson, Justice Henderson. And in this memorandum, Stacy Steinberg documents that she informed the Rules Committee just prior to this rule being passed, but apparently they were never notified while the rule change was going on. And Judge Thomas Temple expressed concern that the rule changes were important and serious changes of a constitutional nature and should not be rushed through. He thought it would be better to discuss the proposal in a committee meeting rather than by email. But rather than do that, the Supreme Court passed, it was Supreme Court Order 1993, and anybody who wants to look it up, all you'd have to do is go on to the court website and Google SCO for Supreme Court Order 1993. And that changed Criminal Rule 6.1 to eliminate grand jury powers. And so you could go on there and see, and they passed it in late November with an effective date of December 1st without a single Rules Committee meeting. Yet the committee members who got notified, and
So how many are in this committee?
There's 13, and Stacy Steinberg documented only 3 of the 13 responded, and 2 of them wanted a full committee meeting because these changes were of a constitutional nature.
So wait a minute. Let me get this straight. There's 13 committee members that are there. Only 3 responded, and 2 of them demanded in-person meetings to occur because they said that it goes against our Constitution?
Correct.
Okay, keep going.
Yeah. And remember, there's a grand jury that is, during all this, a grand jury is currently investigating judicial corruption. And Stacy Steinberg documents the next full committee meeting is scheduled for December 16th. So all Alaska Supreme Court would have had to do is wait 15 days.
This was December 16th of 2022.
Yes, just
so
like a month ago, or not
Okay.
even quite a month ago.
just so folks
And so-
don't think it's this year.
Yeah, they didn't wait, in spite of the fact that what was going on was of a constitutional nature, and I believe, and a lot of other folks believe, it violates our Constitution. And so now we have a grand jury that I'll read some of the things that just do not make sense. One of the changes that the Supreme Court did is they say, let me find it here. A grand jury fulfilling an investigative function on a particular matter under this rule, this new rule, may not also issue an indictment. And so they're investigating this Marla Greenstein for falsifying official investigations and falsifying certified documents, which is a felony. That's what the grand jury is investigating. And as soon as that gets out that the grand jury is investigating that, the Supreme Court comes in and says, you can't indict folks that you're investigating. Yet the 55 delegates to our Constitution wrote this, again, and I'm going to repeat it. The power of grand juries to investigate, the power of grand juries to inquire into the willful misconduct in office of public officers and to find indictments in connection therewith shall never be suspended. Doesn't everybody think that the Alaska Supreme Court writing a rule that the grand jury cannot indict violates what the delegates, what our Constitution says when it says that their power to indict shall never be suspended? And so, and there's quite a few other things in here that they did that violate our Constitution. And so we have been to the governor's office down here in Soldotna. We have a nice lady, Jill Schaefer, that has an office in the Blasey Mall in Soldotna. We've been to her. She contacted the governor's office and the attorney general. I put together a document with the rule changes and what the Constitution says and what the delegates said. And we're asking folks to help us oppose this and to change, to rescind this Supreme Court Order 1993 and to rescind Rule 6.1 entirely before this grand jury is done investigating. And to do that, we are asking folks to consider joining us in a statewide courthouse sit-in at 8 a.m. on March 15th, 2023, until the Supreme Court Order 1993 is rescinded and until Criminal Rule 6.1 is rescinded. And I guess I would urge everybody to look into Criminal Rule 6.1, into Supreme Court Order 1993, and to also contact the governor, contact your legislators. We've contacted all of ours. We've been to the governor numerous times. They do not have the power to rescind a Supreme Court order. The legislature apparently could write a law that would, in essence, rescind it. But when we talked to our representatives, they said that may take years. We may have this unconstitutional rule on the books for years, and it may not ever happen at all because I think I told folks earlier that we'd went to Senator Peter Micciche. He introduced SB 15 to protect the right of grand juries to investigate and the right of the people to go to a grand jury. And it got hijacked by the Department of Law and rewritten, and it would have made things worse. They rewrote it to where a judge would have to approve anything that is brought before a grand jury. And folks think that that may not be a problem, but when you're talking about corruption within the judicial system, when you're talking about corrupt judges, and like we're talking about this corrupt judge investigator, you have to be able to have the grand jury investigate in the face of opposition from judges if they're to get you to address corruption in judges. If the judges can go in and order the grand jury to stop, we have no way to address it.
So if I was to, terminology, so to speak, try to play this into what current politics is like here in Alaska, could we say that maybe ranked choice voting, or maybe the permanent fund dividend and the way they're interpreting the law, the judges themselves, their determination, we want to bring accountability to what they have ruled upon, and we have evidence to prove that they are breaking the laws, we can't do it because of this new rule they just passed?
Correct. Yes. One of the big issues that this rule does is it states specifically, one of the rule changes says specifically this: decisions as to what to present to the grand jury, including whether to present a matter requested by a citizen to the grand jury for investigation, rest with the executive branch. This in itself does not mean that an individual citizen has a right to present any matter directly to the grand jury for consideration. Now I'm going to read you what the delegates said. The 55 delegates who wrote our Constitution said. They said, quote, "The grand jury can be appealed to directly, which is an invaluable right to the citizen."
So what the judges basically have done here is said that we are the all-knowing authority in the executive branch, and until the executive branch themselves gives you that authority, we could care less what you're going to do because you don't have it, where previously we had that right. We didn't have to have their permission.
Correct. And that is a very, very scary situation.
And all those changes happened in what, December of this last year?
Yes. Yep. And so, yeah.
From statehood, we just hit our 100-year anniversary.
Yeah.
And
yeah. Well, and let me back up a little bit, is that this total annihilation of grand jury powers just happened this December, but the first attack on our grand jury happened in 1989. If folks remember, some of you might be too young to remember, but we had a governor named Bill Sheffield. A grand jury in 1989 started investigating him for steering a $10 million lease to a campaign contributor to his campaign. And they didn't indict him, but they recommended that the Alaska State Senate start impeachment proceedings against Governor Sheffield. They in the report they reported that he was untruthful under oath to them, which is perjury. But rather than they didn't know. There were questions about whether they should actually criminally go after a sitting governor or just try to remove him. But immediately after that, the Alaska Supreme Court passed Rule 6.1 to start eliminating grand jury powers, to start suspending them. And what they did is Rule 6.1, tonight I'll have my wife put this memorandum on it, and SCO 1993, and also this flyer that we'd like people to start printing and looking at and signing. One unbelievably important thing occurred is I talked to, the grand jury has an attorney advising them, and I asked the attorney if folks who wanted to get information to the grand jury could give it to him and he would hand it to the grand jury, and he said yes, he would. And so in this document, it's got the contact information for the attorney that can give stuff to the grand jury. And I would like everyone to look at this document. It basically says that we, the people, do not believe the Supreme Court rule change is constitutional. We want it rescinded, and we want all of Rule 6.1 rescinded. So,
and is that Alaska State Corruption, alaskastatecorruption.com or?
it's alaskastateofcorruption.com.
Okay.
There's one other thing that I'd like to point out is in the same documentation we got into how the Supreme Court changed Rule 6.1 is there's an email dated August 16th, 2022 from Chief Justice Daniel Winfrey to Attorney General Craig Taylor. And what I want to point out in this is that the investigation was going on in August. So why was the Rules Committee, who are supposed to write the rules, never notified until late November and immediately before the Supreme Court passed the rule change? Why would you not inform 13 members whose sole job it is to write the rules that you're writing the rules? And like Bert pointed out, especially after the very few that got the notice said, hey, we can't change this rule because it concerns a constitutional issue. Now we know that the Chief Justice and the Attorney General were changing the rules over 2 months before the Rules Committee itself was ever notified. I mean, how is that possible? And
if I was to put on my tinfoil hat for just a second, it really does sound like they were preempting their own indictments and criminal convictions that were going to be charged against them, and this was a way to prevent their corruption from being actually exposed.
That is exactly what a lot of people think, because if in fact this judge investigator has been covering up for judges for 33 years, does anyone think it's possible she might have covered up for one or more of the 5 Alaska Supreme Court judges?
Over some of the rulings I've seen in the last just 10 years, I would guarantee it if I was to be a betting man.
Okay, well, and there's another issue in this email from the Chief Justice to the Attorney General. As the Chief Justice says, I understand you will likely designate John Skidmore and Angie Kemp for the Department of Law to write these rules. If you remember, John Skidmore is one of the very people that stopped all these grand juries when it's a felony. Tampering with a juror is a felony. And we went in and wanted him prosecuted. He is now the very person that was assigned to write the rules, putting the handcuffs on the exact grand jury that is investigating him. I mean, this is scary stuff. On that website, we have documentation where we were emailing with Jill Schaefer, Governor Dunleavy's person there in the Blasey Mall, and telling her and the governor and the attorney general how deeply involved John Skidmore was in the corruption. And this is long before August 16th of 2022. And those emails and documents are on the website Alaska State of Corruption. What is even harder to believe is that when I think I told folks that we were going to go to Juneau and make a citizen's arrest on John Skidmore, and they said, no, we will investigate him. Angie Kemp called me, and I think this recording may be on the website also, but she recorded it and was kind enough to send me the recording. She told me that because John Skidmore was involved, he would be isolated from the investigation. But now with this email, it appears he was not isolated. In fact, it looks like he was made the main man to go in and hamstring the grand jury that's investigating himself and the judges and the judge investigator. So
if me being the person that I am, I would relate this to being like putting Nancy Pelosi in charge of the January 6th investigations when she's the one who was in.
Unbelievably good job documenting what grand juries can and can't do, what they have done in the past, and how officials have always tried to put their thumb on them, because invariably when a grand jury investigates, it's investigating government officials. That's why the people who wrote Alaska's Constitution said that they're supposed to investigate, where it says the power of grand juries to inquire into the willful misconduct in office of public officers and define indictments in connection therewith shall never be suspended. Because if you or I, we the public, do something wrong, the Alaska State Troopers, the Wasilla City Police, the Homer City Police, the FBI, all those entities are more than willing to investigate us and take us to trial. But when those folks, the FBI, the Alaska State Troopers, the Homer City Police, the judges, the district attorney, when they commit crimes, the traditional entities that investigate are now the ones committing the crimes. And that's where the grand jury steps into the picture. But because of that, because rarely do these officials go off the rails, grand juries don't investigate all the time. They investigate rarely. Normally they sit there and indict folks based on investigations done by the district attorney, done by the troopers, done by the city police. And because of that, we lose knowledge that the grand juries have this additional power to investigate. And what is even another thing that is totally unbelievable is I had heard somewhere that the federal grand jury handbooks have been rewritten through the years to hide that the federal grand juries have the same power. And so I got the bright idea of looking at the original grand jury handbook, the earliest grand jury handbook for Alaska that I could find, and compare it to the new grand jury handbook. And the change is unbelievable. The original one says that the grand jury, their most important duty is to investigate, and that the public can apply directly to the grand jury, make presentations directly to the grand jury, and the grand jury can investigate. In fact, they can, it says that when they determine where they want to meet, in other words, a grand jury doesn't even have to meet. You pointed out the Kenai Peninsula Borough Assembly, when we gave them this information, not the stuff on this new rule change, but on how grand juries were being suppressed and how the Deputy Attorney General and judges were ordering them to stop, we went to the Borough Assembly. Unanimously, they passed a resolution stating that's wrong and that it has to stop. The Homer City Council did the same thing. Kenai City Council, we have yet to make a presentation to the Soldotna City Council, but every city council and borough assembly we went before unanimously has passed resolutions, and those resolutions are on that website. But where I was going with this is that the Kenai Peninsula Borough Assembly Legal Department looked into grand jury investigations in Alaska since statehood. And they said after statehood, grand jury investigations were common up until about the late 1980s. And this is about the time that Bill Sheffield was investigated and the first Criminal Rule 6.1 was put on the books. The legal department for the Borough Assembly here, it was like a couple years ago now, I believe, they said after that grand jury investigation stopped.
So Sheffield was basically, the grand jury was investigating him for what was something like a $10 million
Yep.
Donation or for his campaign. And
yeah, Bill Sheffield steered a $10 million lease to one of his main campaign contributors. So basically it was a payback.
Pay to play.
Yeah. And So think about it. If grand juries were supposed to be oversight of all government agencies and officials, and they've not been allowed to do their job for 30 years, that could explain a lot of things. It could explain why we're not getting a full PFD, because the not getting a full PFD violates statutes. A grand jury could have looked at that, seen who officials weren't giving us full PFD, violates the law, they indict them.
So in the committee meetings that the Alaska Ledge had this past year, they were openly bragging about breaking the law, not following the statutes on the books for the permanent fund. And they were giving multiple other examples where they have broken the law on other statutes, one of them being like the longevity bonuses for seniors is a really good, because that's one of the oldest laws they've been breaking. And so what you're saying is we should be able to impanel a grand jury to go and bring these Alaska legislators to accountability for not following the law, but because of what they have done, starting with Sheffield and the current changes, even if we did start an investigation right now to see about bringing criminal charges against them, we can't even do it because there's not a judge in the world that will give us permission, because they put all the authority and power into their hands to make that decision away from us.
Yes, but if you look at what the people who wrote Alaska's Constitution, we still have that power. We're being buffaloed out of it. The judges cannot, a judge's ruling does not supersede our Constitution. And that's what I'm asking everybody, is we all need to band together and say no and free up the grand juries to do their job. And they could look into anything. And I want folks to also know the main reason, there's a couple other good authorities people should look into. One of the very best, and it's written by Marla Greenstein herself, the judge investigator helped write this, but it's incredibly good. The court just they issued rulings to hamstring the grand jury's power to look into corruption by government officials. I'm going to read you one quote in this book from David Haeg. This is a grand jury investigation in California. It concerns that. The San Francisco political machine had even received assistance from the California Supreme Court, which issued rulings restricting the grand jury's efforts. Think of that. You could just change California to Alaska and it would make a perfect fit. So what we're talking about here is that Supreme Courts in other states have stepped in to make sure the grand jury never got to the truth. And that's what's happening right here, is our Alaska Supreme Court, all 5 justices, have stepped into a current and ongoing grand jury investigation to make sure you and Bert never hear the truth. And the grand jury has been subpoenaing people, putting them under oath. I know because I'm one of them. They have been investigating anything and everything. And so, because they're investigating our only judge investigator for the last 33 years, and other folks, doesn't everyone agree we should hear what they find? So
the investigator who's been on the job for over 30 years now, the same person, it sounds like the election official in Anchorage who's been tallying all the votes for all of these years that just resigned or left the organization. It sounds like as long as one hand is washing the other, they can continue on carte blanche, and they're making the sole decision on what happens.
Yep. Well, we have a grand jury that is dug in and is fighting and is doing their job. We, the people, need to back them up. That's the way I feel. Is this grand jury is at great risk because they are investigating the only judge investigator for 33 years. God knows how many skeletons may be in the closet. we need to come to their aid. And all's we're asking, if we go do this sit-in at the courthouse, is all's we're asking is that the grand jury be left alone to do its job, period. And that we get to hear what they find. That's all we're asking for by rescinding this SCO 1993 and 6.1. That is all we're asking for. I'm going to read a little more from where I told you the San Francisco political machine had even received assistance from the California Supreme Court, which issued rulings restricting the grand jury's efforts. I'm going to read a little more, and it'll let folks know what I hope happens here. The logjam began to break when a citizens committee headed by a crusading newspaper editor, influential civic leaders, and an honest district attorney were able to persuade a judge to discharge a controlled grand jury and select a new panel with the help of a special prosecutor and detective. The political machine responded by trying to oust the district attorney and appointing one from their own ranks. In a courtroom hearing that drew a large public audience, the judge instructed the grand jury to act without fear, favor, or affection, saying there's no higher duty devolved on a citizen. Another example in Oklahoma. A grand jury probing state corruption was about to indict 21 officials when the judge dismissed the jury. Remember, our grand jury has been investigating now for, I think, 7 months. And the Alaska Supreme Court, out of the blue, comes out and says, oh, you can't indict anybody. What is going on?
You're getting too close to the truth, and they don't want to be taken down in the process, it sounds like.
Okay, I'm going to read the rest of that sentence. Aroused citizens responded by petitioning for another panel to complete the investigation. What I'm asking you citizens is to join me in going into the courthouse, sitting down on the floor, and just saying we're not leaving until SCO 1993 is rescinded and Criminal Rule 6.1 is rescinded. It is, and all those do is restrict treatment from a grand jury. And the people who wrote Alaska's Constitution said they made that mandatory so that the government would always have to be impaneling grand juries in most of the courthouses. Like Homer doesn't have one, but Kenai does. Palmer has a grand jury, Anchorage, but like some small places don't have grand juries. But the reason why indictment is mandatory is to force the government to impanel the grand juries, because we, the citizens, don't have a way to impanel them. It has to be done by statute and through Constitution. And the reason why it is a requirement that all felonies be indicted by a grand jury is it forces the government, if they want to prosecute anybody for a felony, they have to impanel a grand jury. And the people who wrote Alaska's Constitution says, although we force them to do that, that ain't the most important duty of the grand jury. It's after they're impaneled, if the citizens come to them and want them to investigate, the grand jury is then formed and ready to go. And so it was a brilliant way for them to do it. Because if we had to impanel a grand jury for it to investigate, they would never let us do that. But since the government itself is forced to impanel grand juries to indict anyone they want to charge with a felony, the grand jury, once it's sworn in, it's ready to go. We can go in and say, hey, we want you, after you're done indicting this person for, PFD fraud or whatever, investigate this judge, investigate this judge investigator. And so it's a brilliant way.
And that's the portion that was just changed in December.
Yep, and they're trying to do away with all that. So
took that power away. So
yep, and one other thing, I know I kind of keep going, and I was going to kind of try to find where it is. It's not in here, my notes here. I'm going to do this from memory. Is that in 1989 when Rule 6.1, and that's kind of an odd number, I think, for people. And it's because it was an afterthought. Rule 6 lays out what grand juries can and can't do. 6.1 is where they came in and started putting the chains on, the limitations. And I'll have you know that when in 1989, there were 5 Supreme Court justices, just like they are now, but all of them were different. When they went to pass Rule 6.1, 2 of the 5 justices said it is blatantly unconstitutional and were voting against it. But 3 of the 5 voted it through. But the 2 Justices Burke and Compton, they wrote that, and immediately after 6.1 went in, the Supreme Court used it to suspend and suppress a grand jury report. And it was O'Leary. People could Google this. It was O'Leary versus Superior Court. And what happened is a grand jury tried to investigated they investigated the Anchorage School District for covering up for a teacher who was having sex with his underage students. And so a grand jury looked into that, wanted the public to know what was going on, but the Supreme Court says, oh, we got this Rule 6.1, you can't publish this. We don't want the public to know what's going on. And the grand jury filed a lawsuit, and I'm not sure how it all started, but the grand jury filed a lawsuit. The Anchorage Times filed the same lawsuit, joined it. The Anchorage Daily News, 2 of the biggest newspapers in the state, joined the grand jury. The Anchorage police chief joined it, and 2 district attorneys joined it. There was like 7 people sued the Alaska Supreme Court saying Rule 6.1 was unconstitutional. And there was a point in time where we the people need to put our foot down.
One of those circumstances, I may be wrong here in my assumption, but how being tried in front of the same people that make the decision originally and re-putting them back in front of the exact same people, isn't that wrong? Shouldn't there have been new judges? I mean, shouldn't it have gone out of the Alaska Supreme Court and went to our national Supreme Court instead?
It can't.
Kind of like the Sturgis case is kind of where my brain is thinking.
Yes. If this involved violations of federal law and the federal Constitution, it could. But it concerns violations of our state Constitution. We already looked into that. A bunch of folks wanted for us to gather up money we can and sue the state of Alaska or the Supreme Court in federal court. But because this concerns state law and the state Constitution, the federal government has no jurisdiction, period. And so it is up to we the people. And I have thought long and hard about what to do. And I think a sit-in would get some attention. And it isn't just a sit-in at Kenai. I would ask that every courthouse in the state, even ones that don't have grand juries, in Homer, in Palmer, I don't think there's probably not one in Wasilla, but
no. Palmer's the valleys.
Yeah, Fairbanks, Juneau, Sitka has one I know. Utiavik, Bethel, King Salmon, because this issue affects us all. So anyway.
Wow.
Appreciate your time.
There is a lot to unpack here, I'll tell you what. So the website is located at where again?
It's alaskastateofcorruption.com, all one word, alaskastateofcorruption.com.
And I'll make sure to add that on to the top of the description for what this video is. I know I have already dropped that a couple times into the comments. If you're looking for it, just click the link and it'll take you right there.
And I'll make sure to get you a copy of this memorandum proving what's going on, and a copy of SCO 1993, which is the Supreme Court order changing 6.1. And what I'll do is I'll try to find the verbiage from that O'Leary case where the grand jury sued.
Taking them away, keep whittling them away, and we're not going to have any opportunity to be able to this to our government, because they're going to say we don't have no rights to do that, which this is a prime example of them taking away our rights that we should legally be allowed to have. That is our God-given gifted rights that empower us to be able to be the greatest country in the United States, in the world. And they're taking that away one piece at a time. when you can't even bring the judges and the judicial branch to accountability because they're the ones that are changing the rules that would have allowed that to happen, we got to stand up and fight against it. So take a moment, please like and share this video. You can currently find this on Twitter, YouTube, Facebook, at both Politadick and Politadick Unfiltered. You will find this on Rumble probably within the next 6 hours from now. It will also be found on NorthTube as soon as it mitigates over to that direction. Again, please like, share. Thank you guys all for being here today. Thank you, David Haeg, for having me and getting to discuss about the Alaska grand juries and the judicial corruption that's been going on within our state.
Well, thanks for coming out. Appreciate it.